Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, Mr. Bremer. You may proceed.
Good morning, and may it please the court. I am David Bremer for the appellants Michael and Catherine Zito. Your Honors, due process precedent can no longer guide resolution of sovereign immunity issues in the takings context, because it is now clear that the takings clause provides a self-executing damage remedy in federal court, while the due process clause does not do that. Because of this distinction, due process-based immunity rulings like that in Reich are now inapposite in takings cases, and cases that relied on Reich, like Hutto, are not controlling. So this court must decide the issue based on fundamental principles, particularly the principle that the 14th Amendment binds the states to the duty to pay for every taking. Hutto is the primary case in which the commission relies on to escape this takings claim based on sovereign immunity. The problem with Hutto, as I mentioned at the outset, that Nick made clear that in the takings context, there is a self-executing remedy for every taking, a damages remedy for every taking. And there is
Mr. Bremer, this is Judge Thacker. Where in Nick did it mention sovereign immunity at all, or the 11th Amendment?
Well, it's true that Nick did not come to the court as a sovereign immunity case. So that's not the argument we're making. The argument,
I mean, it didn't leave the court as a sovereign immunity case either, did it? It was more about timing of filing the lawsuit.
Well, it was not quite. It was beyond timing. Prior to Nick, there was no damages remedy for a taking in federal court, only in state court. Nick made clear that that self-executing remedy to get money for every taking applies in federal court as well as state court. That development in the law changes the analogy to due process, because in the due process context, you do not get federal damages in federal court. It only applies in state court. And that distinction means that Reich, which is what this court relied on in Hutto and other courts, Reich is no longer analogous to the takings context because due process does not give you a federal self-executing remedy. So no, Nick,
but the defense here is sovereign immunity. So I'm just trying to understand how Nick impacted the sovereign immunity defense.
Right. I understand that, Your Honor. And that's what I'm trying to explain. Maybe I'm not doing it quite well enough. If I might try once again, and forgive me if I'm redundant here, but prior to Nick, you could not get damages for a taking in federal court. Now you can. So when you look at due process and takings and you hold them together, the one thing you notice now, after Nick, is executing remedy in federal court means that sovereign immunity now clashes directly with the takings remedy in federal court, and you can't rely on due process precedent. So it opens the door for you to look at sovereign immunity in a broader, more comprehensive way than was done in Hutto.
Under your view, do we have to abrogate our Hutto opinion, or does Nick do that?
Well, I don't think it abrogates it. You have an intervening Supreme Court decision that changes the viewpoint for this issue. So now you can't look at it and say, as Hutto did, well, due process cases are allowed in state court, but not federal court. So we're going to do the same thing in takings context. That's not possible anymore, because the takings and due process, you look at Nick, you can also look at Lingle. Takings and due process rules are not analogous anymore. They can't, it's not a one-for-one fit. So Hutto, that part of Hutto, the dependence on Reich, is no longer viable. You have to look at the 14th Amendment. And one thing about the 14th Amendment that's clear, states are bound by the due process clause, which incorporates the duty to pay for every taking. Government must pay for takings, and states are not outside that class of government that's bound by the 14th Amendment clause. So Hutto got around that, but relying on due process principles, but you can't rely on due process principles if there's a federal remedy now in the takings context, and there is not in the due process context.
Mr. Bremer, you raised a fair point. You're right. I mean, it does raise question as to whether or not the self-executing remedy exists. And Nick said it does, but that may be true, but it doesn't open the door as to the question of what does that say in face with sovereign immunity under the 11th Amendment. That's the problem. It doesn't, Hutto doesn't clash with it, but it does raise another aspect. But the question that I think Judge Thacker was asking you was about how do we reach that with Hutto there? Do we ask for en banc for the rest of our colleagues to hear it? But I agree with you. It does raise the question, since you can't just say, as Hutto says, oh, it's not self-executing. Nick says, yes, it can be in federal court, but there was a town. So that's our question. How do we navigate this, I think, well-taken point that the landscape is different, but how do we navigate this new land? Well, right. as a panel.
Right, and I guess, Judge Gregory, it depends on how you read Hutto, how far you read Hutto. So if you read it as I read it, which is avoiding some of the more fundamental constitutional principles and saying, as maybe a compromise, look, state courts are open to hear these claims, then we're going to apply sovereign immunity because Reich does the same thing in due process. If you read it that way, Your Honor, then I think you as a panel can go a different direction because Nick changes the reliance on Reich. If you read it more broadly, Your Honor, if you read Hutto more broadly as really getting into the fundamental 14th Amendment issues of sovereign immunity, then maybe that's a different question. But I don't see it that way. I read Hutto as
Counsel, hi, this is Judge Motz. This argument has been put to 3 other circuits, right? And they've all rejected.
This argument has not. No, not this argument. This argument hasn't put to any circuit.
I beg your pardon? I'm not saying that you argued that the argument has been made.
No, it hasn't. In none of these other circuits, you don't. What I mean by that,
none of them have decided that their previous Hutto-like precedent was overruled by Nick. You don't know of any of those cases?
I don't know of any other case, Your Honor, which has argued that Nick neutralizes Reich. Nick neutralizes Reich.
No, that wasn't the question I asked you, is it?
Well, I thought
so. The other circuits have a Hutto-like precedent, and they had the question before them if Nick overruled it or whatever you want to call it, limited it, and they all rejected that argument, didn't they?
They haven't rejected our argument, no, because our argument.
They rejected an argument that made that argument,
well,
right?
They rejected an argument. Yes, I agree with that, but they didn't reject this argument. They didn't reject the argument.
What it said was what the 2 cases, I think Judge Motz is talking about the 5th and the 6th Circuit that said that Nick did not alter the sovereign immunity framework, correct?
I believe
Ladd and Bay Point Properties.
Your Honor, there are.
And the Second Circuit has an unpublished opinion that says the same thing.
None of those cases, and I'm going to turn it, and I'm going to assume, if you give me a second, I'm going to assume a reading that agrees with you for a minute. But first, I'm going to say this: those cases.
I was quoting from the case.
Right, I understand.
Okay.
Those cases, those counsel in those cases, the plaintiffs and appellants in those cases did not argue that Nick divorced due process and takings law, and that changes the calculus. They did not argue that. But let's assume there's a conflict. It's okay to be in a conflict if you're on the right side of a conflict. And in this case, you would be on the right side of the conflict by holding that the 14th Amendment, which binds the states to pay for takings, applies. That's the correct ruling. Now,
would we be the first circuit to do that? Are there any other cases that support your position currently?
Yes, I think you would probably be the first circuit to correctly hold that the 14th Amendment abrogates sovereign immunity because it requires states to pay for takings, which is a well-settled principle at this point.
And in your view, we would not be in conflict if we so held with the 6th, the 5th, and the 2nd circuits?
I think that would be less of a conflict than it looks on its face because of different arguments. But to the extent there is a conflict, you would be on the right side. But let's say Hutto controls. Let's just turn and say that you can't get past Hutto, as Judge Gregory suggested earlier. Well, then what do you do then? Then you have to decide whether state courts are open. And in this case, the state courts are not open for the Zetos to get compensation for their taking because the commission concedes they must go through a separate initial proceeding to try and invalidate the regulation, then wait for the state to decide whether they want to do an eminent domain action. And then maybe the Zetos can file a third action later on to try an untested, uncertain, speculative procedure that's never been done before. So
But why would they, just as a matter of, I don't know, logic, why would a two-step process be wrong, be different? What makes that? I understand you said it won't happen, but leave that aside. It can happen.
Well, Your Honor, I would say at the outset, you might be able to get compensation somewhere at some point from someone is not an adequate, reasonable, or certain damages remedy for the purposes of the federal takings clause. But let's just give them.
That wasn't my question. I asked you. You posed it to us that you couldn't do this in a single step. And what I'm saying is, if you could do it in two steps, why would that make it different? Why would that make it inadequate?
Two reasons, and I'm sorry for answering your question a little bit more directly. I mean, indirectly. I'll answer it more directly. One reason, because under the federal takings law, you look at Nick and Williamson County, there is no exhaustion requirement to get damages. And if you require the Zetos to go and litigate an entire procedure without getting damages so they can go get damages, that is an exhaustion requirement. Number two, my second reason is this. This procedure, the two-step, which is really a three-step if you look at page 50 of their brief, because we have to wait for the state to decide whether they want to condemn it. This three-step procedure is not a reasonable or certain procedure to get damages. And that's the test for us. It's not their test, well, maybe you could try it, perhaps you'll get it. It's whether it's a certain reasonable procedure for the Zetos to get damages for every taking. That's what the federal constitution requires, not what we require. And they're not going to guarantee that because we have to go through this sort of dinosaur procedure. Yes, it's a dinosaur, but it's on the books to invalidate invalidate their action. And then they say we have to wait for the state and the commission to decide. We might be able to file a temporary takings claim that's never been done before after all this to finally get damages for the taking. That is not reasonable or certain or adequate. And for that reason, the state courts are not open even under Hutto, and therefore we are still past sovereign immunity based even if Hutto continues to apply. I want to make one more point along those same lines about sovereign immunity, and that's this. There's no basis in sovereign immunity law or the just compensation clause for takings claims to trump in sovereign immunity in state court, but not in federal court. The commission concedes that as a general matter, state courts are open to takings claims because the just compensation clause is self-executed and the immunity must bow to that. But they say it not in federal court. There's no basis in the law for a court-dependent or a forum-dependent understanding of just compensation and sovereign immunity. Just compensation is the same in state and federal court, and after Alden, sovereign immunity is the same in state and federal court. The principles are all the same. So there's no reason in the law, in doctrine, to say sovereign immunity bows in state court, but it bars takings claims in federal court. If you look at that principle, if you look at
taking up that argument, if the federal government can impose limitations or conditions on the use of sovereign immunity in federal court, it has done it. Perhaps not in this situation, but it certainly does put conditions on the invocation of sovereign immunity.
Well, I respect.
Okay, for purposes of my question, why don't you assume I'm correct now? I recognize that you don't think I am, but assume I am, and the federal government can do that. Why couldn't the state government do that?
I'm sorry, I can't. The Tucker Act of 1887, I think you're referring to, Your Honor, the Tucker Act of 1887, which gave Court of Federal Claims jurisdiction over some damages claims against the federal government, contracts, torts, and claims under the Constitution. Since that time, the Supreme Court in Jacobs 1933 has made clear that you don't need any statutory authorization for a just compensation claim, even in federal court. So it actually helps our cause because there's been development since the Tucker Act was passed, which shows that you don't need, that the takings clause does it by itself. It gives a damages remedy for every taking against the government, and state governments are now part of that class of governments after the 14th Amendment subject. But even if that's not true.
Okay, I just want to be sure that we are speaking the same language.
Okay.
I'm talking about procedural requirements as conditions of waiver of sovereign immunity that are imposed under federal law. Why couldn't the state do that? And your answer is that the federal government doesn't do that. Is that your answer?
Yes, my answer is that.
Okay, but if the federal
after
government
Jacob-
did do that, excuse me, if the federal government did do that, that would be precedent for a state government doing it, correct?
No, I don't think it would be. I think you would have a different analysis under the 14th Amendment, but I don't think it.
Now you think the states have more powers over sovereign immunity than the federal government? Is that what you're saying?
No, what I'm saying is that it's absolutely clear that when the 14th Amendment, that the balance of power was changed and that the states were meant to be bound by the requirement to give due process, which includes just compensation. So yes, maybe it would seem dichotomous to do that, but the correct analysis of the 14th Amendment is that every state is bound by the due process clause, and there is a duty for states to pay, look at First English, for every taking that they commit. I need to stop right there, Your Honor.
All right. Thank you, Mr. Bremer. Mr. Park?
Thank you, Your Honor. And may it please the court. I'm Ryan Park, appearing on behalf of the North Carolina Coastal Resources Commission. In Hutto versus South Carolina Retirement System, as we just discussed, this court squarely held that states may not be sued in federal court for takings claims as long as state courts remain open to adjudicate such claims. This rule decides this case. Plaintiffs are essentially seeking to relitigate Hutto and establish a directly contrary rule based on the takings clause's self-executing character. But of course, a panel of this court cannot overrule another panel's decision merely because it finds convincing new arguments made by a new party in a later case. But even if it could, the takings clause's self-executing character has been well established for nearly a century since the Supreme Court's Jacobs decision, and it was considered by the Hutto court, which rejected this feature of the clause as a basis for departing from the ordinary sovereign immunity rule. And the court in Hutto stated, and this was quoting 7-Up Pete Venture, the Ninth Circuit case, "We conclude that the constitutionally grounded self-executing nature of the takings clause does not alter the conventional application of the 11th Amendment." And so this issue was squarely raised and decided in Hutto, and we think it decides this case. Now, plaintiffs' next argument is that this court should reconsider Hutto in light of the Supreme Court's recent Nick decision. But as Judge Motz mentioned, every court of appeals to have considered this question has thus far held that Nick, because it did not involve sovereign immunity, does not bear on this question. Instead, Nick merely concerned a timing issue of when a plaintiff has a ripe takings claim. But ripeness, of course, has nothing to do with sovereign immunity, because ripeness is about establishing a valid claim, whereas sovereign immunity is an affirmative defense that limits federal jurisdiction over otherwise valid claims. And so the commission believes that Hutto remains good law, and that under that standard, the only question remains is whether North Carolina courts remain open to adjudicate takings claims against the commission.
Wait, can you address that for us, please?
Yes, Your Honor. So the North Carolina provides a clear and certain procedure, or as we agree with Mr. Bremer, that the standard is reasonable and certain procedure to guarantee the ability to challenge commission's actions as a taking and to receive full compensation when a court decides that a commission does constitute a taking. Now, we believe this is a two-step process, not a three-step process, as Mr. Bremer just mentioned, because the second step is really two alternative pathways, and there's no sequencing required. As soon as a commission action is deemed to be a taking by a state court, and that is appealable to the North Carolina Court of Appeals, the North Carolina Supreme Court, then either the state or the landowner can file an action for compensation, and the state can say, we exercise our eminent domain authority. So we're going to take fee simple ownership over the property and provide you just compensation. And everyone agrees that that process complies with the takings clause. The only question is whether, and on the first step, when the commission's actions are deemed to constitute taking, then it invalidates the commission's actions, and so that's effectively an injunction against the commission's actions, which by the way goes beyond what is normally provided under the takings clause. And so then the only question is this interstitial question of
Mr. Park, before you leave the first step, you said something very important. You said as soon as it's determined that it's a taking. But when does that have to happen procedurally under state? For example, the first thing is they say, well, you can't rebuild your home where it was on the site before it burned. All right, that was a decision by the commission. What is the process for them? You said it kicks off as soon as they determine that that is a taking. Has the commission decided yet that that's a taking?
No, Your Honor. So what happens is the commission's decision.
No, I know the procedure. I'm asking you, is that deep? In other words, if I can't build my house where I want to build, why is that not a taking? Because you said as soon as it's determined to be a taking. How does that process work? Can you wait a year to make that determination? 6 months, 6 days? Tell me that, because that's your words. You said as soon as it is determined. Tell me how it is determined and when and what process.
So as soon as the commission denies a variance or denies a permit, then the property owner immediately has a right to go to state court and ask that action be invalidated as a taking. And the statute actually mandates an expedited process. So that takings determination has to be given peremptory setting even over criminal cases. So it's an extremely expedited process for challenging the regulatory.
You can go straight to Superior Court as soon as the commission says you can't have the permit. Is that right?
That's right, or denial of the variance. That's correct. And so that is, a very expedited process. It can be initiated immediately after the commission takes any action. And again, if that action is successful, then the commission's action is invalidated. And there's only this interstitial question of during the time in which the property owner's rights were being held up, is the compensation for that temporary taking? And we agree that's mandated under First English.
Well, tell me this then. Now, we're in the Superior Court now, which you say you can go from commission not giving you the variance or the permit, and then you go to Superior Court. Let's say you win, and the Superior Court then decides whether it's a taking, correct?
That's correct.
All right. Where is this process where then the state can determine whether or not it's going to initiate an eminent domain? Isn't there a process?
That's
right?
Correct. Yeah. Yes.
Well, why would that be an issue? It's a taking. Who cares whether you want to be in eminent domain? Now the question is, give me my money. Tell me that's where it's in the sauce right there. Why is there a step between the Superior Court saying this is a taking, and then now the state can say, well, we'll decide whether or not we're going to start eminent domain? That's the problem. You shouldn't have that. That's the question. Is that adequate? The next step is, what is my just compensation? Not whether or not the state has an option to initiate eminent domain. Tell me that.
Well, so the reason why the process is bifurcated in that way, Your Honor, is because after a state court rules it's a taking, the commission's actions are wiped off the books. They are invalidated. And so the just compensation pathway is allowed for the state to say, we actually do want to continue in our regulatory action, even though it's a taking, and we will pay just compensation. So the state has the option to continue the taking going forward.
What do you mean? What's the option? Give me the A and B. You said option. What's the A and B?
So the A is, we would like to continue the restriction on the plaintiff's property, which here is a denial of a permit to rebuild the Zito's home.
You've already done that.
But if I'm
denying that.
So I'm sorry, the takings procedure, because plaintiffs filed this action in federal court immediately, There has never been a
don't
takings
tell
procedure.
court. I'm talking about the procedure that would be adequate here.
Right, so
go ahead. What's the option they have after the Superior Court has said this is a taking? You
That's
said
right.
the state has an option. Give me the A and B or C or how many options there are.
So there are two pathways to compensation there. So first is the Zetos say, we would like to proceed as if the regulatory actions are invalidated, and we will rebuild our home and then file a second lawsuit a direct lawsuit under the North Carolina Constitution for the time during which our property rights were being held up. So that is a temporary taking. If the state can come in and say, we actually want to effectuate our policy, and we will provide you full just compensation. And so there are two pathways depending on whether the state would like to continue its regulatory action or whether it will acquiesce in the invalidation of its action.
Well, if it continues that option, then when will you when are you going to pay them their money?
So that would be according to the second step of the process, which would be an independent constitutional claim. I don't. Sorry.
Why would you have to make a claim if it's already determined it's a taking? That's the problem. That gets to Mr. Brimmer's question. That is, the Fifth Amendment has been incorporated by the 14th Amendment to be incumbent upon the states to comply with. And sovereign immunity cannot stand in the way of, for example, your right to a lot of rights, the right to remain silent, all those things in the Fifth Amendment. And taking is very important. Matter of fact, the framers were very interested because the king could take the barons' land and all those things. They want to make sure they were protected in that. And that was important. There you tell me, you take the land, now they decide, wouldn't the next thing be, if it's going to be adequate, pay? Now their home is worth something. The question is, what is it worth? Why is that you can then play around and say, not play around, I don't mean that sense, but then you got another procedure. Well, we'll decide whether or not you then have to have a separate claim. No, you have to answer, why are you continuing to take and not compensating justly? And
with respect to Judge Gregory, sorry.
That's where this panel can deal with. Because Hutto did say it has to be open and have some reasonable basis that you can adequately adjudicate and get justice for your Fifth Amendment taking. And so that's probably, it seemed to me, it's very complicated and sort of mysterious in terms of what you said in that. Why can't you go from your state court? This is not a question of sovereign immunity. Your state court said this is a taking. Why wouldn't an adequate remedy be now, let's have a forum to decide what the value is?
Respect to Judge Gregory, I don't believe that at that level of scrutiny and analysis would be consistent with Hutto. So when Hutto said that if the state courts must remain open to adjudicate claims, takings claims, it did not engage in that level of scrutiny of the South Carolina system. What it did was it cited a South Carolina Supreme Court case that said, like there are many North Carolina Supreme Court cases, saying that plaintiffs may bring direct constitutional takings claims. And it said, because that procedure is open, a direct constitutional claim, then the state courts remain open for takings claims, and sovereign immunity applies in federal court. And I don't think that it would be possible for the North Carolina Supreme Court to have spoken more clearly on this question. It said that the sovereign immunity, the takings right is not susceptible to impairment by legislation. That's from Midget. And then went on to say that where the Constitution points out no remedy and no statute affords an adequate remedy under a particular fact situation, then the plaintiffs can bring a direct constitutional claim. And because the North Carolina courts are open for that kind of claim, that's the level of analysis that is required by Hutto.
So what court do you go to in the state once the Superior Court says it's a taking? What court do you go to immediately? I want my example. Here's a hypothetical. I've gone to court, I paid money to litigate this, Superior Court, I won. It's a taking. So the Fifth Amendment is actuated by letter and reality. What do I do to go immediately to get my compensation?
The very next day, or that day, after a state court holds that is a taking, the landowner can file an action in that exact same court before the exact same judge, saying, now that you've adjudicated the commission's action as a taking, I want just compensation for the time that my property was held up, because now I have an injunction and I want money for the time that my property was held up.
Has that ever happened?
We are not aware of any situation where that has happened, Your Honor, because no party has cited a case where a state superior court has held that a commission's action constituted a taking. There are several cases. Yes, Your Honor.
No. So the question of somebody asking for compensation for a temporary taking has, to your knowledge, never been come up. Is that right?
I believe so, although I think that the North Carolina courts have established that it is following the first English precedent that a temporary taking is compensable.
Mm-hmm. Okay.
And, so there are several cases, including the Midget case, by the way, where a plaintiff attempted to bypass the statutory procedure and never went through the camera process or a process by a different statute and filed a direct constitutional claim. And that is what happened in Midget, the North Carolina Supreme Court case. And the Supreme Court said that you have this right to file a direct constitutional claim. So it is.
Did the person get any, excuse me, did the people get any relief?
I believe that was remanded. So I'm not aware personally whether it was deemed to constitute a taking in the end.
Could a North Carolina resident bring a direct constitutional claim in federal court?
It would be, it could bring the claim, but it would be barred by sovereign immunity for the reasons that I discussed earlier.
What about a federal constitutional claim in state court?
Yes,
federal constitutional claim.
Yes. So in Midget and several of the other cases, what the plaintiffs did is they filed parallel state and federal takings claims, and the North Carolina Supreme Court didn't distinguish between the two kinds of claims because it has read the state's takings protection to be coextensive, but it allowed both cases to proceed to the merits.
I interrupted Judge Gregory, I think.
No, it's so. Go ahead.
Thank you.
But you said this when they brought the federal claim in state court. You said in one instance, you said that was sovereign immunity problem still.
Oh, I'm sorry. So I think the North Carolina case law is clear, and again, I would point to Midget as the best case, that a takings plaintiff can file both state and federal constitutional takings claims in state court and have them resolved on the merits. But in federal court, obviously our position is that sovereign immunity bars a federal court from resolving the claim. And if I may, I'd like to touch on a point that Judge Motz was making in the colloquy with the opposing counsel, which is essentially this Ruckelshaus rule. And in that case, the federal government has, in many instances, conditioned a waiver of sovereign immunity for takings cases, for takings claims on some administrative or first or conditional process. And so Ruckelshaus was this kind of obscure provision involving pesticides. But what the Supreme Court there said is there was an arbitration scheme set up by an initial statute. And that arbitration scheme didn't allow for recovery to the full extent of the just compensation clause. And so it said that can be a first stage of a process. And then you can file a second Tucker Act claim for any remaining compensation that you might be owed under the Constitution. And as the Sixth Circuit mentioned, held in Ladd, because Nick reaffirmed that process, that two-step compensation process, it suggests that sovereign immunity principles still remain active in the takings context, and that Nick wasn't intended to abrogate sovereign immunity in the takings context. But it has a special resonance here because that was a two-stage process where there was a statutory scheme.
Mr. Park,
Yes,
tell me that if you bring a federal takings claim in state court, what law is going to apply as to what is a taking?
You could bring parallel state and federal claims.
What law is going to apply if you bring the federal taking action in state court of North Carolina? What law would apply? What substantive law?
Yes, Your Honor. It would be the law of the United States Constitution as interpreted by this court, the U.S. Supreme Court.
Right. It would be so taking, so the question is, in North Carolina, you don't believe really that not being able to build is really a taking, do you?
That's correct, Your Honor. We intend to defend these takings claims on the merits at the appropriate time.
Right. So it's not a taking. So should federal law honor that? Federal law is kind of simple. I own it, you took it, just compensation. Yours is I took it, but it's not taken.
Well, we don't believe that under federal law this would be a taking, and our merits defense, or one of our merits defenses, would be under Lucas, so versus the South Carolina case in the U.S. Supreme Court, where the Supreme Court said that where there are background principles of property law that are being applied to restrict development on a landowner's property, that is not a taking. And here, the Zitos purchased this property, many decades after these setback requirements had already been in place. And when they did purchase it, they knew or should have known that the ocean was encroaching on the coastal property. I mean, there used to be an entire row of houses in front of the Zitos' home. And I'm not sure when the direct home in front of it, that property was taken by the ocean, but they purchased this property knowing that there were setback requirements and seeing that the ocean was approaching. And for that reason, we believe there's not a taking here.
Do they pay taxes? Do they pay taxes on that land?
I would assume so, yes.
Yeah, so the state of North Carolina was collecting taxes on it. They were just own a property like anybody else owns property. You never said you can't live here, did you? You didn't condemn the land and say it was not habitable, did you, as a state?
That's right, Your Honor, and that would be our second merits defense.
When they're ready to build their own property back on their own site now, oh, well, it's not a taking. Matter of fact, you should have never lived there. That's what you're saying, that they knew all along. But the question, that's the problem. Is it really open if the state is saying, well, this is not a taking anyway? And therefore, that's a serious question. And we don't have to rely on Huddle to say that. The question of whether or not there's open, we're not bound by that at all. It just says, that's really your burden, isn't it? Almost.
So I don't believe
people say it's both because they have to show us inadequate. But based on what you're telling me, is I hear it. It's very difficult to say, an action of eminent domain, because eminent domain has many functions, right? In order to do it, you have to show there's a public need. You can't all those things go through it. You say, well, there's a public need there. We really didn't take land we can use. So what's the public quid pro quo? Eminent domain has a lot of aspects to it. You start getting into that. But the court says that the Fifth Amendment is important and states have to yield to it under the 14th Amendment is incorporated. And so that the question, and maybe you're right, Nick certainly didn't deal with sovereign immunity, but it's certainly the idea, as you said before, well established, that is a self-executing remedy. And maybe this is the arcane aspect of North Carolina law that may be cleared up here in terms of maybe or maybe not. Is maybe not adequate to address a clearly established and a very important right that the framers, matter of fact, probably the framers may have been more important with this than any other right, really, in terms of this. Certainly didn't secure a right to vote and things like that, but it did about property.
Counsel, before you sit down, can I ask you about, are you familiar with the Penn Central case?
Yes, Your Honor.
So how do you think that it relates here?
So I think sorry.
Go ahead. No, you go ahead.
I think that the Penn Central analysis would be, the second part of the marriage dispute between the parties when we eventually get there. Whether the state's action was reasonable and whether it intruded on the state's, the property owner's rights to the extent that it was in effect a taking. So I think that that's a merits question that the state courts.
Well, earlier when Judge Gregory was talking to you, he said under federal law, a taking is a taking and you don't make any determination. But of course, that's what Penn Central was arguing. And the Supreme Court rejected that argument. That you have to, that's correct. Sure, the law is so very different.
Yeah, I mean, I think the regulatory takings doctrine is multifaceted and complicated. But what I'll say is that it is not the case that any development restriction is a per se taking that requires compensation under the federal Constitution. It's under Penn Central, it's a balancing test, and it's about the intrusion on the property owner's rights, and also this issue of the background principles of property law and whether they're being applied in a neutral way, and if so, that suggests it's not a taking.
Thank you.
If I may just, well, I'm over my time, so.
Your time is up, but you may briefly. We did pepper you with some questions. Go ahead.
Thank you, Your Honor. I'll be brief. So Hutto establishes the rule that if the state courts are open to adjudicate a takings claim, then sovereign immunity applies in federal court. It does not require a guaranteed remedy, does not neutralize any other applicable defenses that a state might raise, such as, for example, statute of limitations. And under the Hutto rule, all that's required is that there remain an open procedural pathway for full compensation. And because North Carolina provides such a pathway, the commission asks the court to affirm.
Thank you, Mr. Park. Mr. Bremer, you have some time reserved.
Thank you, Your Honor. It shouldn't take 20 minutes to explain how a property owner gets money when it's determined that there's a taking. One thing is clear in this case. My co-counsel admits that the Zitos must go through a procedure. Look at page 50 on their brief, page 50. They must go through a procedure that cannot get them damages to find a taking. Once they go through that procedure that cannot get them damages for a taking, then depending on what the state's course of action is, they say, then maybe there will be an eminent domain action filed against the Zitos in a different statutory procedure. And then maybe they can file a temporary takings claim under this general principle that North Carolina has, that some takings are compensable. That is not a certain procedure, and counsel concedes it must be certain for damages, regardless of what federal law says about whether there's a taking or not. It is absolutely clear that when there is a taking, there must be money right then. That's First English, that's Nick, and that is settled law. But you don't get that here in North Carolina. What you get is this convoluted explanation that maybe you can do this and maybe you can do that, and there's no precedent, but we think 2 steps, maybe 3, depending on what the state does. Look at page 50. Then maybe the Zitos somewhere down the line will get money for a taking. That is not what the federal Constitution requires. It requires payment for every taking, and the commission, is trying to avoid that through an arcane procedure that, yes, was adopted 30 years ago, and it's no longer valid in light of First English and Nick, but it is the law for now. The legislature can change it, but they haven't done that. They've left this procedure in for the Zitos to go sue for a taking, but not get money, to spend all their money, but not get money when a taking is found. And that is not reasonable or certain and adequate. And so this short court should it hold that Hutto controls and its sovereignty generally applies, that in this limited circumstances where there's an old statute that doesn't give damages, that the state courts are not open, and the Zitos must be able to go somewhere, in this case a federal court, where they get money when a taking is found. That there's certainty on that. And that is the fundamental problem with their argument. Again, please look at page 50 and how they argue this case, and you'll see all the steps that you have to go through. This midget case that they're now citing to is just simply a 1960 general case about, yes, in states generally must pay for takings. It has a general principle, but it doesn't apply specifically to the commission. And the commission has argued in this case throughout in the district court that the exclusive procedure is statute 113, which does not give compensation. That was their defense to this case originally. When we filed this case in federal court, their defense was this: you have to use the exclusive procedure in 113. You can't go to federal court. And so now they're backtracking a little bit and say, well, maybe there's another procedure. It's not that exclusive. That's not what they argued before. And regardless, it doesn't matter. We have to go through a procedure that doesn't guarantee us compensation. That's not open. And I'll stop right there. Thank you, Your Honor.
Thank you so much, Mr. Bremer and Mr. Park. Thank you so much for your arguments. Can't come down and meet you as we would love to, No, nonetheless, we very much thank you for your arguments and helping the thorny issues in this case. We appreciate it so much. Be safe and stay well. Thank you.
Thank you, Your Honor.
Counsel for the second case can unmute.
All right. Ms. Grafton, you may proceed.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. My name is Rebecca Grafton, and I represent Ingrid Nolasco Figueroa and her 2 children, the petitioners in this case. This is the case of a young woman, a mother of 2 small children, whose partner was murdered on a soccer field in plain sight in Honduras. After killing her partner, the murderers, the Santos family, announced to the crowd that they were going to murder his family members as well. This threat was credible enough that the petitioner moved 4 hours away from her home with her 6-month-old baby and 2-year-old child to go live with her grandmother. About 1.5 years later, it became clear to her that this relocation was not enough to keep her and her children safe when her partner's brother Mardoni was murdered about an hour away from where the petitioner was staying. Just before leaving to come to the United States, the petitioner again realized that she had not successfully relocated when she saw a daughter of the Santos family at the local market only about 15 minutes from where she was. Fearing for her own life and the lives of her children, knowing her persecutors were close, she fled to the United States. About 6 months after arriving in the United States, another one of her partners was murdered. The petitioner successfully passed her credible fear interview upon arriving to the United States, provided a written affidavit in support of her application for asylum, and testified credibly before the immigration judge, both under direct and cross-examination. She provided credible testimony and corroborated her claim with the police report regarding her partner's murder, the death certificate for her partner's brother's murder, a news article about the Santos family, and other background documents, including birth certificates for herself. And
How does the death certificate and newspaper article corroborate her claims?
Well, Your Honor, the death certificate corroborates her claim because it does provide objective evidence that she is telling the truth about Mardoni's death specifically. It does corroborate that the date she provided, both at the border—
That he's dead.
That's correct, Your Honor, that he is dead.
But not that he was murdered.
That's correct, Your Honor, and the immigration judge focused on that in her decision as well. However, as the petitioner testified before the court credibly, the family was afraid to advise the government of Honduras what the manner of death was for fear of their own safety. In reviewing the death certificate itself, there is no specific location for a manner of death to be indicated. There is a notes section, but there is no manner of death like the death certificates we have here in the United States.
Right. So maybe you're more corroborating evidence on that than is the police report, which does say that they're investigating a murder and who specifically they're investigating, correct?
That's correct, Your Honor. That would be the most important piece of corroborating evidence. And notably, the immigration judge fails to discuss that in her finding on whether the petitioner met her burden of proof. On page 66 of the administrative record is where the immigration judge goes through the corroborative evidence. And as we argued in our briefs, she listed out every item of evidence. We don't deny that. But then she goes on to make this finding that the petitioner did not adequately corroborate her claim, but doesn't discuss why that police report isn't enough.
But what about the threats? What evidence corroborates the threats that were made?
Well, what's corroborated is her credible testimony establishes that, Your Honor, and there is no doubt that
corroboration is different. You're right. Sometimes the testimony of the person can be enough, but that's not. My question was what corroborates.
I think what corroborates is her actions itself. The fact that she felt that she was afraid enough to move with her 2 young children 4 hours away.
Wait a minute, now you're arguing circling now, because obviously she says it, and then obviously that's going to would influence what her emotions. What corroborates it outside of her actions and her testimony?
Your Honor, there was no independent corroborative evidence on that specific point. I would admit to that, Your Honor.
That's not a specific point. That's a very important point in terms of the threat, because that's what we deal with, the threat being made as to weighing the threat that was made to her, because this is a case where there was no violence to her directly, so therefore it's derivative. And the question is, for example, the sister-in-law or the niece, there was no statements from either of them, correct?
That's correct, Your Honor.
Well, what corroborating evidence was there then, other than her testimony and her actions, as you say, that could be one could infer that might be consistent with having that view? Was there?
So, Your Honor, the petitioners would argue that she is not required to corroborate every aspect of her claim.
I'm not arguing with you about that. I'm asking you, do you concede that there was none?
I do concede that there was no other additional independent corroborative evidence on that point. However,
you concede that under the framework of the law, that can be properly considered when it's reasonably expected that one would have that type of corroborating evidence. You agree?
Well, I think that's the question, Your Honor, is whether we would reasonably expect her to have that corroborative evidence. And we would argue that for two reasons. One, the immigration judge erred in that she never made that finding, Your Honor. She never made a finding in her decision about whether that evidence was reasonably available, which, as we noted in our 28J letter, this court in Wambura recently held that she is required to make that finding about whether it's reasonably available. So for that reason, we would argue that.
Are you saying that the BIA did not mention anything about the fact that there was no statement at all from her family?
Well, the BIA specifically states that the evidence was reasonably available. However, there is no findings that are made to support that sentence. So even though the BIA casually glosses over that, there is no finding, which is what this court requires. Not simply that the issue of reasonably available be mentioned. And the immigration judge herself does not make a finding about whether the evidence is reasonably available. She just specifically states that the petitioner gave no explanation. However, that, as we discussed in our brief, it doesn't match with the record, Your Honor. The immigration judge asked my client that question, but then she cut her off before she allowed her to provide any explanation. And as this court held in Lin John, the immigration judge has a duty to get that information from the petitioner as to why is this evidence not here in the record. And that's where the immigration judge erred on this point, Your Honor.
So you're saying that the law is that you can't consider a lack of corroboration unless you ask the question, where is it?
Lin John specifically states that, and it cites a Third Circuit case in Lin John, but specifically holds the immigration judge needs to provide the petitioner the opportunity to explain why that evidence isn't there. And she did not do so in this case. She asked the question, but the record's clear that she cut off any sort of explanation and never touched back on that. She moved on from that point entirely.
But didn't petitioner provide a response to the question when the immigration judge asked the question? I mean, the response was arguably non-responsive, but there was a response to the question.
Your Honor, if you're reading through the transcript, it looks like it was an issue with the interpreter, that the petitioner gave a response. The interpreter had some difficulties, and then we went back to that point on getting the petitioner's response into the record, but it was not completed. The immigration judge went on to go discuss these issues with the death certificate from Ardoni that we've discussed earlier today. And so that was an error. The immigration judge had a duty under Lin John to make sure that the petitioner gave an explanation. In fact, there's no facts in the record for the immigration judge to make a finding about whether or not those affidavits are indeed reasonably available.
Sorry, I don't know who was talking, but I interrupted. Okay. So your argument is that because the immigration people failed to make a factual finding that corroboration was reasonably available, that we must remand. But the IJ did say that she did not, quote, did not find respondent's explanation persuasive and considers it reasonable to expect such corroborating evidence. And your contention is that we can't read into that the finding that corroborating evidence wasn't was reasonably available. Is that right?
Yes, Your Honor. Well, there's two issues with that. One is that the immigration judge's decision does not match the record. And the immigration judge finds that my client's explanation was not reasonable. However, there is no explanation for the immigration judge to rely on for that. And so it's not supported by the facts that are in the record. And then secondly, yes, Your Honor, we would argue that the Wambura case is clear. The immigration judge needs to make a finding about whether that evidence was reasonably available. And I would argue that a finding is more than just glossing over in one sentence that, well, the petitioner offered no explanation and thus she didn't establish it. This was an issue that the immigration judge had a responsibility to make sure if she was going to deny for lack of these corroborating statements, she needed to make sure there was an answer to her question.
But what if the answer was science?
If the answer was science, Your Honor, we would expect that the immigration judge would then go on and in her decision explain why my client's answer was not reasonable, that it didn't.
It just did what Judge Bach just told you. What's basically, I find it not to be adequate. And you're saying that's not enough because you must make a finding as to why it's not. You're saying that it would be expected that you would have that, especially in a case where no threat was made to you.
Well, Your Honor, I think there's two issues there. One is that the immigration judge, it's not a lack of responsiveness from my client. It was an issue with an immigration judge who was anxious to get to the next point and did not complete that line of questioning with my client. There was an issue with the interpreter, and I note to AR 146, which is where this happens. There's an issue with the interpreter on line 9, 10, 11, 12. The judge tells the interpreter to interpret as much as she could from what my client had started to say. And then she went on and started to discuss this issue with Walter's death with a death certificate and not following up with my client as to why those statements weren't available. And, in the BIA brief, we argue a presumed explanation, a possible explanation, which is the fear of the family. And while we argued that in our BIA brief, that's certainly not facts before the court. It was offered as argument that there may indeed be a reasonable explanation. It just was never, the immigration judge never gave my client the opportunity to present that to the court. And that was an error. That my client did mention when she was talking about the death certificate that we discussed earlier, Judge Gregory, that her family was afraid to tell the police or tell the government why Marjoni was deceased for fear of their own safety. And I think we could argue there that if that fear would also likely prevent them from providing these statements to the court. However, again, turning back to the record itself, that never happened in court. That question, that answer, it was cut off and the immigration judge moved on.
But she's talking about at JA 146, she did answer a question and talk about, she asked for the death certificate and they needed witnesses, but that they didn't want to go and testify to get the death certificate because of fear. She did provide that answer as the reason why she didn't get the death certificate.
That's correct, Your Honor. And that was the second brother who was deceased, Walter, the one that was murdered 6 months after she came into the United States. And I think it was the question that the immigration judge was asked was very overarching. And of course, keeping in mind that there was an interpretation involved by the time that question got to my client was, why didn't you get a statement for the family for any of this? Well, she started explaining this death certificate for the second murdered brother, but there was a lot of things the immigration judge was asking in that question, and she never went back to follow up with my client about whether that information, what the answer was to her question. Why didn't you get those affidavits?
Counsel, you want us to believe that it was the immigration judge's fault that your client doesn't have corroboration?
Your Honor,
what did you think?
No, it's not, Your Honor. What I'm saying is that it's the immigration judge's error to fail to review the evidence that is in the record and instead focusing on the evidence that's not in the record, which matter of LAC, the agency's own precedent is very clear on that rather than focusing on what's not there, the immigration judge should have focused what was in the record, which, as Judge Thacker noted earlier, the police report regarding her partner's murder, it goes back to what the point is of corroborative evidence. And we don't want to lose sight of the fact that my client, the petitioner, was found credible. She testified 3 times. She gave a credible fear interview at the border with no attorney representation. just after making that trek to the United States with her children. Then she provided a written declaration as well as her asylum application. And then she went through this direct and cross-examination in front of the court, and there was no inconsistencies, no reason to believe that she was not telling the truth. And so the immigration judge required corroborative evidence, which we don't dispute. She has the authority to do. But what we would argue is that matter of LAC doesn't allow the immigration judge to list out which specific items of evidence would be required. And notably, the additional evidence is subjective. This court has held that these affidavits would have been given limited weight anyways under the Jaju case that the immigration judge cites herself. So there's a lot of problems with this level of proof that the immigration judge is holding my client to. She's not recognizing all the information.
I have one quick question before, I know your time's up, but hopefully this won't take too much time on a different issue. Where in your opening brief do you challenge the BIA holding of ineligibility for withholding of removal?
We do not challenge that in our argument, Your Honor. I would say that if the law is very clear that if my client doesn't establish eligibility for asylum, she would fail in withholding of removal itself.
All right, thank you.
Thank you, Your Honor.
That's it from me anyway.
I see I reached my time. I'll reserve the remainder for rebuttal, Your Honors.
Thank you, Ms. Grafton. Mr. Holt.
Good morning, Your Honors. May it please the court, John Holt for the Attorney General. It's always a privilege. We have a former judicial colleague up in Washington, District Court Judge Stanley Sporkin, who loved to say, there's always a key that unlocks every case. The problem is to find the key. We come before the court this morning with the key that unlocked this case. And it's very simple. The petitioner had the burden to establish that she could not produce corroborative evidence that was reasonably available. That's the number one point of ruling of the agency that's dispositive of all our other claims.
Also, excuse me, I hear you on that, but the finding of the AJ was that she didn't find that respondent's explanation was credible, was persuasive. Never asked for an explanation. I mean, your argument isn't matching each other.
Well, we would submit if we go through an algorithm, it will help the court to understand that the finding is supported by substantial evidence. Where I really think we should start is a top-down view, a global view to understand this case. It's unique in front of the court, and we would submit that you don't see this that often. And the petitioner comes before this court making a claim that she has absolutely no knowledge of either personal harm or personal threats. Judge Gregory focused on this in his questions. So what we have here is an immigration judge that hears a witness come in and say, this is what I've been told, this is what I've heard. On page 179 of the record, that's exactly what she stated. So she has no knowledge. And the law is quite clear that credible testimony may support a claim for relief or protection, but it doesn't mandate relief or protection. And where the petitioner or the witness has absolutely no knowledge of the underlying fact, justifiably, the law says that the immigration judge may require corroboration if it's reasonably available. This court's opinion in Singh is consistent with longstanding board precedent that the burden is on petitioner to come in and establish that the evidence is not reasonably available. So after the evidence was necessary, then we come to, what did the judge do? The judge did more than he ever had to do. Here he identified very specifically the missing evidence that he would like to see, and the judge would like to see. And that was, as you focused on, first of all, information from percipient witnesses, people that had knowledge. And how does that translate? That translates to affidavits of anyone that had any knowledge of any harm to anyone in general, or death to anyone in particular, or secondly, threats to anyone. And the immigration judge wanted petitioner to address why there were absolutely no affidavits from anyone regarding those matters. Secondly, the immigration judge identified, as you focused on, the death certificates that were admitted and missing in the evidence. With regard to Walter, there was no death certificate. And with regard to Mardoni, there was a death certificate, but as Judge Thacker pointed out, there was no indication that what the cause of death was, or even that it was an unlawful killing. So the immigration judge found that corroboration was necessary. The immigration judge very generously identified specific evidence. And then third, the immigration judge did give petitioner a very reasonable opportunity to address why that evidence was not available. Indeed, it was the questions of DHS counsel on page 145 of the record. And then page 146 to 148 is a series of questions by the judge regarding particularly why evidence was not available. And if we could submit one fact to this court regarding the unavailability, it's petitioner's admission that she never asked for the affidavit. The court is asked here to say that the judge didn't give petitioner an opportunity to explain. The petitioner said to the court, I didn't even try.
Well, can I ask you about a piece of corroborating evidence that is in the record, which is the police report? Did the IJ engage with the police report at all, other than to list its existence?
The immigration judge indicated that page 185 is the police report. You're correct, Your Honor. And what's significant about that, as you pointed out, it only identifies that there were suspects. And the suspects have the name Santos.
No, wait. What I'm asking about is whether the IJ did anything other than say that the police report existed. Did the IJ meaningfully address or engage with or consider the police report?
The IJ did, in the sense that the IJ said after the IJ concluded the petitioner had not reasonably corroborated her claim, her testimony, the IJ said it was incumbent upon the judge to evaluate whether the other evidence independently corroborates the claim. It was in that context that the IJ did go to page 185 of the record and say, here's this police report, but the report only indicates that these people were suspects. And as you pointed out, Judge Thacker, the newspaper article at page 209 and 210 does not tie in any way to the Santos family.
Right. So the police report, I understand the police report itself is in the record at 185. What I'm asking is, where does the BIA or the IJ, anybody, talk about the police report and why it is not sufficient corroborating evidence?
First of all, again, in context, the agency concluded first that petitioner's testimony did not produce the necessary corroboration. So that being said, there's a vacuum. And then the question is, the immigration judge went further, was whether the other evidence filled that vacuum to establish her claim. In that context, the immigration judge did mention the police report. I will inform you, Judge Thacker, that the board did not mention specifically that police report. It was submitted that they didn't need to go through every piece of evidence to evaluate and explain why it in itself didn't corroborate the claim. They went through and said that there was other evidence with regard to the affidavit of the petitioner, the death certificate of Mardoni, the article with regard to the family, the whole litany of evidence that is relevant to corroboration of the claim the agency did consider. So we would submit that.
So is it the government's view that the police report is not legally sufficient evidence such that the BIA can just ignore it and not meaningfully engage with it?
It's the government's position that substantial evidence supports the agency decision that the evidence that she submitted to corroborate her claim was insufficient to establish her claim. Indeed, the board here acknowledges on page 4 of its opinion that another fact finder may view the evidence in a different light. We see this all the time. But in terms of the standard of review for this court, it's substantial evidence. We would submit that to say that police report alone, and Judge Thacker, we would submit that if you evaluate it, that's really all there is. The death certificate of Mardoni doesn't, her affidavit doesn't, the newspaper article doesn't. So you're faced with solely the police report. Is that sufficient to establish that the evidence compels a contrary result?
Right. Well, she was found credible, and she said she had a fear of death because these people killed her husband or live-in boyfriend, and then the police report says that they're investigating the very people she mentions for murder. Don't those two things together corroborate her claims if in fact the BIA had considered the police report coupled with her credible testimony?
Well, we would submit that you must look at this case through the substantial evidence glasses standard of review. And while that is some corroboration, yes, the question is, does that particular piece of evidence at 185 compel the conclusion that she established her claim? We would submit that it alone does not, or in conjunction with any of the other evidence.
Yeah, I think, Mr. I think you're saying, but you said it's not enough to carry the burden, because I think what you're saying is that she's credible. That's undisputed. Her belief, her fear is credible. The person died, and you could say he was murdered. It's a tragic case. But the problem is his being murdered and by someone, and who alleged it is, means that person did not like him, obviously, when they murdered him. And she's fearful, which is an appropriate response. But the question here is, as a family member, were you in fear? Was there a threat, a threat that they would then take because they murdered this person, they want to murder you? If otherwise, that would mean somebody in your family is murdered. That's all you need to hear. The question, though, is this is a case where there's no evidence of any threat made to her. And that's why the cooperation was important, because I think that's what you're arguing, that even you consider the death certificate and assume it was murdered and by somebody who didn't like him. And the question is, she was able to live for several months without a threat being made to her directly, written or otherwise. I think she saw somebody who was related to the Santos, and she was fearful. That person didn't make a threat against her. So what they were saying is that it seemed like a case like this, you would have something to say, there's a threat because this person said they were going to do something to me or everybody in the family. And the question is there substantial evidence to support that, not whether or not he was murdered or by whom? Is that right?
Your Honor, when you appear before the court, what you want to do is ask the right question. You just asked the right question, and that is the substantial evidence support the agency decision. And you're correct, and we've come full circle. Where we opened with was to have the court be informed that its decision should be informed with the factual context of this claim. And you just now focused on that. She has no personal knowledge of any action or threat to her person or harm. Now, certainly she appeared credible with regard to what she had heard, what she had been told. And but then again, that's why the law in its magic or insight does say to the immigration judge that even though a person is credible, even they're otherwise credible under the statute, you can ask for corroborated evidence if it's reasonably available. And again, I think the important idea here is that she had the burden. as you pointed, Judge Gregory, the proponent of the evidence, if they're silent, and, why was this evidence unavailable? You're the proponent of the evidence. And here, she admitted that she hadn't even tried to get affidavits of any person with regard to the percipient witnesses. And that goes even further than the niece and the sister-in-law who, first of all, had information about deaths of the brothers. But regarding the death certificate, it was speculation on her part that people were fearful to state the cause of death or inform the authorities with regard to the cause of death, being the Santos family, because they feared the Santos family. Well, again, that's speculation on her part, and she produced no affidavit from anyone that was the reason. The board realized that she didn't, and my colleague admitted that they didn't make that argument to the agency. The board still took it on and said, hey, that fear of the Santos family being a deterrent to provide information on the death certificate really makes no sense, because here they're providing affidavits in the United States regarding the Santos family, and how's the Santos family going to find out about those affidavits? So the board knocked down that straw man. In summary, we would say very simply that if you look at, first of all, the necessity of the evidence, the missing evidence being identified, the opportunity that the immigration judge gave her to explain the deficiency, her failure to do so, and admitting with regard to the affidavit, she never even tried, and then the immigration judge's finding establishes that she didn't meet her burden. And there can be no doubt that the immigration judge made a specific finding. The board on page 4 of its decision specifically stated the immigration judge made that finding. And the immigration judge did it very delicately. First of all, the judge found facts. And then secondly, he stated the law, and he started with the law that who has the burden. And on page 96, he said that petitioner didn't satisfy her burden. We would say
can I ask you, sorry, counsel, I'm sorry to interrupt you, but you have the ability of a trial lawyer to talk on one breath for a long time. So let me ask you this question. You're familiar with Wambora, right? Our recent case, which says we require the agency to determine whether the corroborating evidence was reasonably available. Okay. Okay. Now the IJ drew the conclusion. She explained that she did not find respondent's explanation persuasive and considers it reasonable to expect such corroborating evidence. But where did she ever ask for that? I just don't understand exactly. Are you saying in this particular factual situation, you don't have to have the agency determine whether the corroborating evidence was reasonably available because of the facts of this case that you went through with Judge Gregory?
No, Your Honor, we're not making the argument that the agency didn't need to make that finding. We're making the argument that both the immigration judge and the board quite clearly made the finding that Watruba requires. They were prescient in this regard. Of course, that case was decided by the agency's decision.
The administrative law judge said that he did not find respondent's explanation persuasive and considers it reasonable to expect such a persuasive corroborating evidence. That isn't a finding that is reasonably available.
But the immigration judge specifically cited LAC in stating on page 94 of the record that the petitioner had the burden to establish the unavailability of the evidence. And then on page 96, the immigration judge specifically concluded that she had not met her burden. And that's why the board on page 4 said the immigration judge made the specific finding that she did not produce did not establish that the evidence was not reasonably available. And again, Your Honor, I would submit petitioner with regard to the affidavits didn't even try. She didn't even ask for the affidavits. So how can the court say that a proponent of the evidence that goes before a judge and doesn't even say they tried establishes that the evidence is not even reasonably available. I would invite you to look at this case comes down to just a few pages of the record, pages 3 and 4 of the board's decision, pages 94 and 96, and particularly pages 94 and 96, and then the record, pages 145 through 148. Those pages speak volumes. Thank you. We ask you to affirm the agency decision.
Thank you, Mr. Holt. Ms. Grafton, you have some time reserved.
Ms. Grafton, I think maybe I'd start with where your colleague ended.
That was my plan, Your Honor. I'd like to note that my colleague noted that there was only a certain number of pages of evidence that were relevant in this case, and I think that's precisely the point, and that's exactly what the government wants to do, is specifically, he does not reference page 185, which is that police report, and that's one of our main arguments here, is that the immigration judge did not consider all of the corroborating evidence in the record, as is required under matter of LAC, as well as this court's precedent. I'd like to point out that matter of LAC gives us a really great glimpse into what the agency's interpretation of the statute is relating to what corroborative evidence should be provided to the court. In matter of LAC, footnote 5 on page 522 of that decision lists out types of corroborative evidence we would expect to see in a case, including proof of the applicant's name and place of birth, evidence of relevant events in the country, documentation of medical treatment if there was any, and applicant's political participation. This is objective evidence that gives credence to the testimony that the petitioner provides. In this case, we did just that. We submitted that objective evidence, the police report, which we would expect to see. If someone was murdered on a soccer field, we would expect to see a police report, and that was submitted. You know, if someone's deceased, we would expect a death certificate, and that was submitted. And so for that reason, I would argue that we provided precisely the objective evidence that matter of LAC indicates that an immigration judge would want to see in a case, just to prevent an asylum applicant from making up a story, becoming very good at giving those facts to the court, and then the court having no reason to deny the case because there was no basis for an adverse credibility finding.
But the police report is no corroboration of the threats.
Well, correct, Your Honor. It does not reference the threats, but it is corroborative that the petitioner is telling the truth. This isn't some made-up story. It's corroborative of the truth.
Ms. Grafton, may I ask this question? You're right. She was deemed credible, and the problem is this case. You need, I think, it's important to have corroboration because, for example, the question is, how do we know what was told to her is true here? And like you said, it's right there because that's what was told to her. But the corroboration here at least says, yes, that's what I told her, that's what I heard, that's what I saw. So that's the corroboration here because, am I correct? This is based on a threat because of family member, right?
That's correct.
Right? This is not the government. The Attorney General does not dispute that you're a family member and the mother of his children. They were partners. That's fine. There's nothing wrong with that. But the question is, how does this derivative circumstance have the threats? And as to, I think Judge March asked a poignant question to Mr. Holt, and that's the question that they ask about it. But that is the answer when she says, I didn't ask. Well, he could or she could say, why didn't you ask? Or why didn't you do that? I don't think it's required to do that. You've given the answer. Because the question is, why don't you have corroboration? Answer, I didn't ask. That's the end. Because it's not that I didn't ask because blah, 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 blah. I didn't ask because they were unavailable. The answer is, I didn't ask. That is the answer. So you want us to rule that, oh, well, then you have to go further and ask that question again, and again, and say, you should have it. Why don't you have it? No, you answered. I didn't ask. That's a categorical response to why there is no corroboration. It's as categorical as you can get. So what would they do? They would say, well, you need to. I'm going to sit here until you give me a reason. No, I didn't ask.
Well, Your Honor, I think there's...
How do you get around?
Well, I think where the immigration judge errs is that there was a reason that she didn't ask, and that reason was never put into the record. And if looking through the transcript itself, you can see where the immigration judge is actually cutting off the response, keeping in mind again that there's an interpreter involved. And so rather than like you and I, we can have a question and an answer back and forth, there's a third person in the middle who is taking these sentences and having to cut them off at a specific.
Was the reason fear?
Well, Your Honor, I think that's a fact that's only in the record as much as she testified that the family members had a fear as far as giving a reason on the death certificate.
Because she did say that that was the reason, was fear, with regard to that one death certificate of Walter, I guess it was.
That's correct, Your Honor. And one of...
They never say why she didn't have a statement from the sister-in-law or the niece. That's the threat. The death wasn't the threat. The death was an actus reus, but it wasn't a threat.
And I understand that, Your Honor, and I would argue that the point of corroborative evidence is objective evidence that shows that the petitioner is telling the truth, that these events did in fact happen. I would argue that she did in fact show that. And as far as the threat to the family members, the fact that two other brothers were murdered after that point by the same people, as far as the family believes, I think is evidence of that, Your Honor. This isn't just that her partner was murdered and she became fearful and that was the end of it. Her partner was murdered, she moved away, her partner's brother was murdered, she came to the United States, her partner's second brother was murdered, and here she is presenting a case to the court. And if I can make one last quick note, Your Honor, I'd like the court to keep in mind that my client at 21 years old entered the United States on June of 2016. This hearing was held before the immigration court on May of 2017, less than a year after her entry. And I think that's important when thinking about what corroborative evidence was presented to the court. And with that, I'd rest on the briefs, Your Honors.
Okay, well, thank you so much, Ms. Grafton and Mr. Holt. We appreciate it so much. I wish you could come down and greet you. If not, please know that we appreciate your, these are very difficult questions, and it's very important to have very competent counsel, as you both are, help us with these. So I hope that you'll be safe and stay well. Thank you so much.
Counsel for the next case can
Mr. Martinez, you may proceed.
Good morning, Your Honors, and may it please the court. The jury in this case ordered Puma to pay a record-setting $22 million in damages for defamation. It did so even though there was no actual real-world harm to Mr. Eshelman, and even though the statements at issue were not defamatory per se as a matter of law. This outlier verdict should be set aside for three reasons, which I'll try to quickly summarize up front. First, there was no personal jurisdiction over Puma. The district court based jurisdiction on a letter that Puma sent all its shareholders around the world, including a few in North Carolina. But that letter didn't contain the alleged defamation. It merely printed a link to Puma's investor webpage, where a separate link to these subsequently created PowerPoint slides was eventually added 4 weeks later. The non-defamatory letter, which predated and which 3 clicks removed from the later created slides, didn't form the basis of Eshelman's claim and couldn't give rise to jurisdiction. Second, the statements at issue weren't defamatory per se. Puma didn't accuse Eshelman of personally committing the fraud. It said he was involved in the fraud in a more general sense. Eshelman himself conceded that involvement in his testimony to Congress, where he accepted responsibility for his failures of omission and oversight with respect to the fraud. And finally, Your Honors, the outlier damages award was grossly excessive here. Eshelman offered no proof of any real-life harm. The final award was twice the size of his own self-serving estimate of damages, and it was more than 10 times the size of the next largest defamation award in state history. North Carolina allows presumed damages, but it doesn't give juries a blank check, letting them pluck arbitrary numbers out of thin air. The damages award should be remitted or sent back for a new trial. Your Honors.
Counsel, can I ask you a factual question? What is your best estimate of the number of people who viewed the presentation?
Your Honor, I think the record shows that in the year and a half after the presentation was posted. A grand total of 198 people downloaded the presentation. And that's
No. I'm talking about the total amount. The presentation was available on Puma's website. That's true. And there were 198 times it was done. But we don't know how many people viewed it on the web site of the SEC. And Puma stipulated the presentation could be viewed online. So I think you consider all of those and tell me what your best estimate is.
Your Honor, I don't have a basis for estimating how many people viewed it from the SEC website. I do think that it's notable that it was viewed less than 200 times from Puma's website.
It's not at all notable if it was viewed 2 million times from the SEC's website. And I understand that you don't have any ability, but you have more ability because you are involved in this case and presumably an expert on SEC. So
sure,
if you don't want to venture anything, that's fine.
Well,
you don't argue that it wasn't available on the SEC website or online. Is that correct?
It was available on the SEC website, Judge Motz, but let me just say a word on that. I can't estimate a number, but I do think that if it was viewed by a lot of people, I think we would have seen some evidence of actual harm to Mr. Eshelman if people actually interpreted it in the way that he suggests it had to be interpreted. And if he suggests this was such a terrible thing that was said about him, we would have seen some evidence somewhere. They probably would have put forth at least one person who read it and believed it. In fact, they only put forward two pieces. They identified two individuals only who had read it, and both of them said, that's Mr. Gross and Mr. Lee, both of them said they didn't believe the PowerPoint presentation. And so I think in a circumstance in which—
Well, I'm just not even, I think this is a sidelight, so we shouldn't spend any more time on it. But a lot of us read the New York Times, indeed follow the New York Times or the Washington Post, if you heard our arguments yesterday. And I don't know that we believe everything that is said or disbelieve it, but we hear it, we see it. So I just don't.
That's fair enough, Your Honor, and I'll turn to personal jurisdiction, but the last comment I think I'll just make on—
turn to damages. I think maybe that might be your strongest argument here.
I'd be very happy to turn to damages, Your Honor, and I think that your questions really kind of speak to that point. I think that in a circumstance, here we have a situation where the damages that were awarded were based on a presumed damages theory. And the reason they could pursue that theory is because they brought a defamation per se claim. As you know, we don't think that the statements were defamatory per se, but let's just assume we are in presumed damages world. And the test under North Carolina law is that presumed damages are available in defamation per se cases. But even in those cases, they need to be estimated to a reasonable certainty under the circumstances. And they have to be an estimate, however rough, of the probable extent of actual harm. That's right out of the North Carolina standard pattern instructions and how the jury was instructed here. And here, I really think there's no connection, no rational connection between the massive damages award in this case and the actual harm that Mr. Eshelman suffered. And I think there are three basic points to make. First of all—
the concepts of specific damages and general damages different kinds of compensatory damages?
I think those are different types, but I think that we're not contesting the idea that general presumed damages were available. What we're saying, though, is that even in the cases when they are available, even in circumstances like defamation per se cases, where the law recognizes that it's going to be harder than usual for a jury to put a precise number on the damages award, the jury's amount still needs to be reasonable. And we know that from cases like the My Gallons case and also the Fontenot case. Fontenot case was a companionship case, but it involved a similar problem where the loss of companionship damages are hard to estimate, and the law recognizes that. But courts nonetheless, and this court nonetheless, held that under North Carolina law, you can't just pluck a number out of thin air. It needs to be a reasonable estimate. And here we think there are three major problems with the jury's ultimate conclusion as to the presumed damages. The first one is the fact that there really is no good reason to believe there was actual harm. We think, and we talked a little bit about how many people may have read the statement, we don't think there's any real reason to think that a large number of people read the statement, whether you go by the 198 number that's in the record, or even if you think about how many folks may have read it on the SEC. I mean, these statements—
Well, that is in the record, too. We just don't know the number, and you're not willing to give us any approximation.
Well,
so it might be limitless.
It could be it could be limitless, but as I said, I think the reason—
Well, that's a problem for you, isn't it?
I don't think so, Your Honor, because I think if it really had been viewed by a lot of people, we would know that by one of two things. Either they would have introduced evidence of someone who'd read the statements, or they would have introduced evidence of some actual harm that befell Mr. Eshelman. And here we know that Mr. Eshelman's reputation remained intact. The voluminous evidence that was presented at trial showed that even after the defamation happened, he continued to serve on 7 boards of directors. He received an honorary degree from the University of North Carolina. He received the CEO of the Year Award. He received the Star News Lifetime Achievement Award, and he was inducted into the North Carolina Business Hall of Fame. These are not the hallmarks of someone who's been somehow, his reputation has been torn to shreds by a defamatory statement that appeared on, page 12 of a PowerPoint presentation that was buried on a couple of websites. And so there's really no reason to think that in a circumstance in which Mr. Eshelman received so many awards, in which his reputation was reaffirmed so many times, even after the defamation, there's no reason to think that there was any real harm here, and certainly not harm to the level of $16 million. I think the second
was represented at trial, isn't that correct?
I'm sorry, Your Honor, I couldn't catch that.
Puma had representation at trial.
We were represented by counsel at trial, yes.
So these arguments could have been made to the jury, right?
Yes, Your Honor.
And presumably were made to the jury.
That's right, Your Honor.
Okay.
They were made to the jury, but I think what North Carolina law recognizes and what federal law recognizes is that trial courts and appellate courts don't just sit and rubber stamp jury awards. And in a circumstance in which a jury picks a number out of the air that's arbitrary and violates the instructions it was given, which is to make a reasonable approximation of the probable extent of actual harm, and it picks a number out of the air that's not justified, that's precisely why we have appellate review of these kinds of awards. And I think that's the kind of analysis that this court engaged in the My-Gallons case, where it held that a $4 million defamation award was too much, and that had to be sent back. I think a second indicator, though, of the idea that the damages award in this case was wildly excessive is look at what Mr. Eshelman himself said 4 times before trial. So under the federal rules of civil procedure, he had to tell us what amount of damages he thought he had suffered. And 4 times, over and over again, he pegged the extent of the actual harm he suffered at $7.5 million. He said that over and over again. And obviously, he was incentivized to wildly overinflate that number in the way that plaintiffs often do when they're bringing estimates.
Excuse me, I thought he made different estimates of the amount of damages he suffered.
Right. So before trial, in the Rule 26 disclosures, 4 times, he said it was $7.5 million, which is less than half of what the jury awarded. Now, later in his deposition, he said it was $100 million. At trial, he said it was incalculable. And then in the closing statement, his counsel said that the number was $52 million. And so I think if you look at the sort of blizzard of arbitrary numbers that are being thrown out there, I think what they show is that what's really going on here is pure conjecture. Eshelman was picking numbers out of the air and throwing them around and hoping that something would stick. And he was able to persuade the jury to give him a big number.
So what is the remedy? Counsel, what is the remedy then?
I think the remedy in this case, Your Honor, would be a remittitor or a new trial on damages. I think a remittitor is probably the cleanest way to bring this case to a resolution. We've said in our briefs that, this is the biggest presumed damages award, biggest compensatory award for defamation in North Carolina state history. If you wanted to remit the award so that it was tied for first instead of first, I think you could bring the compensatory award down to $1.5 million. We think that's still too much, but we would be willing to live with that. We could all put this case behind us and move on to our various other endeavors. I think if you weren't comfortable with picking a specific number, we think the best approach would be just to remand for a new trial on damages. Either of those 2 remedies would be appropriate, Your Honor.
Is that really plausible? Because liabilities seem to be pretty heavily attached to damages. So a new trial just on damages seems a little difficult.
I think you could have a new trial on damages. I do think the jury would have to consider some of the same evidence, that was presented before. But I think the question that the jury would be facing would be one that it would be appropriate to ask it to resolve again, which is, given everything we know about what was said here, what's a reasonable estimate of the harm to Mr. Eshelman? But again, I think that the remittitor option is a perfectly good option, and we're not.
it is the option that we have usually taken, and that we set what the remittitor is. We set it for a new trial or take this remittitor. And your highest bid here is $1.5 million. Is that right? Even though the gentleman got $23 million.
Well, Your Honor,
That doesn't sound like remittitor country.
Well, so he got 16 million or so, just under 16 million on the compensatories. So we've proposed 1.5 on the compensatories and a proportional reduction of the punitives. And the reason we think that's reasonable is because that would put Mr. Eshelman's award here at being, he would have the largest defamation recovery in North Carolina history. And I think if you look at the cases that are the next two largest, which are the only other two defamation awards in North Carolina history we've been able to identify, they're 1.5 million and 1 million. And if you look at the facts of those cases versus here, we think there's a world of difference. And in fact, those plaintiffs are were much more deserving of a recovery of that size than Mr. Eshelman. In both of those cases, their livelihoods these were law enforcement professionals whose livelihoods were destroyed by widely publicized defamation, essentially alleging that these folks were either perjuring themselves or were making up evidence against criminal defendants. So that was a livelihood destroy. No one was putting those people in the Law Enforcement Hall of Fame after that defamation was committed. And so we think we're trying to be reasonable. We're not stuck to a 1.5 number. We think, frankly, it should be lower, but we're willing to accept that because we think that would give Mr. Eshelman the biggest recovery in North Carolina history. We think that would be a fair and equitable way to just resolve the case so we can all move on. Our company, my client's company, is trying to develop cancer drugs. We've got other things to try to focus on. And we're trying to sort of find a reasonable middle ground. But we don't think it's reasonable to go beyond that because because there's no evidence of any actual harm, because the comparative cases that Mr. Eshelman relies on and that the district court relied on here really have nothing to do with the facts of this case. I mean, the Cantu case was a case, Your Honors, where there was a large award for defamation, but the defendant in that case had accused the plaintiff in a widely circulated magazine that was distributed around the world of drug trafficking, of bribing the president of Mexico, of conspiring with Saddam Hussein. The plaintiff had lost multiple contracts worth hundreds of millions of dollars, and he was being investigated by the U.S. and Mexican authorities. And that case has nothing to do with this one, and yet that's the case that Mr. Eshelman and the district court cited to justify this outlier award in this case. And the two other cases are not on point either. So I think for all of those reasons, we think that the compensatory award here is wildly overstated, has no basis in the evidence or in common sense. And I think there is a middle ground here. If you think, if you conclude, we would disagree with this, but if you conclude that the defamation verdict stands and if there was personal jurisdiction, we think a reasonable middle ground here is to give Mr. Eshelman a recovery that's equivalent to the biggest in North Carolina history. We'll end the case there, and we can all move forward. Your Honors, if I could just say one quick word on the defamatory per se question. I do think, Your Honor, that the statements here were not defamatory per se. We do need to win on either statement. If we win as to either statement, that would be enough for a new trial. If we win on both statements, that would be enough for judgment. The defamatory per se standard in North Carolina law is extremely high. It's very difficult to satisfy, and that's what differentiates defamatory per se claims from defamatory per quote claims. Here, the statements that Mr. Eshelman was involved in fraud was not defamatory per se, because unlike what the district court said, no one was accusing Mr. Eshelman of personally committing fraud. They were accusing.
What does involved in fraud mean? How is that not defamatory?
It's not defamatory, Your Honor. First of all, it's involved is a broad word, and it doesn't mean personally committed. So what it meant here was that Eshelman was involved in the fraud in the sense that he was in charge of the company, PPD, when the fraud happened during the trial, and he didn't report it to the FDA. And if you look at JA...
And the slide could have said that. And I understand the slide, there was a link to his statement, but the slide didn't say he was involved to the extent he didn't report it to the PPA.
Your Honor, I think the slide didn't accuse him of personally committing the fraud, and I think the slide laid out the surrounding circumstances and had links to the PowerPoint testimony. If you look at the PowerPoint testimony at page 1598 of the joint appendix, you have I believe it's at the top of the page there. Mr. Eshelman is being confronted by Congressman Stupak, who clearly isn't.
You said that this did not, you all didn't accuse him of personally being involved in the fraud, but it says Puma's board does not believe that someone, wonder who that someone is, who was involved in clinical trial fraud should be on the board of directors.
That's right, Your Honor.
That is accusing him of, if he's the someone, of being involved in fraud.
We accuse him of being involved in the fraud, but we think that's different from personally committing the fraud. And the way in which he was involved. It is,
but that's not what, but that's.
But right. what we said involved.
So if someone could read this to believe that he personally committed the fraud, you agree that would be defamatory because you don't, that's not what you're saying.
I think that could be right, Your Honor, but just to be very clear, the North Carolina standard is that if there is a plausible reading of the statement that is not defamatory per se, then that's enough for us.
And what's the plausible reading of the statement that's not defamatory? And the statement being, just the state does not believe that someone who was involved in clinical trial fraud, blah, blah, blah.
Right. The plausible reading is that he was involved in the fraud in the sense that he was responsible for the company, and he did not report the fraud to the FDA. And I think just a final point on this, Your Honor, on 1598, he accepts responsibility. I don't think Mr. Eshelman would have accepted responsibility for his failure to bring the fraud to light if he had been totally uninvolved. And I think that's enough to show that what we understood, what my client understood when the statement was made, was he was involved in the fraud in the exact same sense that Mr. Eshelman accepted responsibility for the fraud. But, Your Honor, I see I'm out of time. I'll just say, if you disagree with us on this, I would go back to the damages argument, Judge Motz. It is the part of the case that strikes me as the most, the biggest problem in the case. And I do think that there is a straightforward way, even if you think that the liability judgment was sound, I do think the fraud, the defamation damages should be knocked down very substantially. Thank you very much, Your Honors.
Thank you so much, Mr. Martinez. Ms. Locke.
Thank you, Your Honor. May it please the court, my name is Libby Locke, and I represent the appellee and cross-appellant, Dr. Frederick Eshelman. Puma's appeal follows a 5-day trial in which an 11-member jury, after deliberating over 2 days, unanimously found that Puma falsely accused Dr. Eshelman of being replaced as CEO of the company he founded after being involved in clinical trial fraud. Judge Dever, as a district court judge, was entirely correct in rejecting Puma's damages argument that it makes and remakes here today, and recognizing that based on the circumstances of this case, there was compelling, Judge Dever's words, and overwhelming evidence that the jury heard that supported both the verdict and the damages award, citing also the extensive...
Let's deal with that overwhelming evidence of the damages. Now, I'll talk about the per se later, but let's talk about the damages. In that sense, it was presumed damages. That was the posture it was in. But what about the quantum of damages? What was the evidence as to the quantum? And I'm going to flip the question, the very good question Judge Motz asked about how many people saw it on the SEC. Well, if that was available, was that introduced by your side to say this how many people saw it? What's the evidence of the quantum of the damages?
Yes, Your Honor. To the point of how many people saw this, we did present evidence that this defamation went around the world. It was seen by individuals not only throughout the United States, but also throughout the world. And I'd point, Your Honors, to the
94 people seeing it in separate companies would be around, countries would be around the world, wouldn't it?
And this was also sent to industry analysts at Bank of America and Vanguard in the very industry pharmaceutical sector that would cause Dr. Eshelman the most harm. But I think it's very important.
Counsel, can I follow that up? Tell me what this evidence was. In other words, we had an estimate of this 198 on the website, and then we have it on the SEC website, and then we have it was online, Puma said. So what fills that in is, I think, what Judge Gregory and I are trying to find out. What evidence is telling us how many people looked, if there is evidence, how many people looked at the SEC website or Puma's website?
We don't know. We know that there were hundreds that saw it on Puma's website in the two different places. I think the number was 450. We don't have a number from the SEC, but the facts in this case were stipulated to that it is permanently available online. And the North Carolina pattern instructions clearly say that you don't just look at the current harm, but also the future harm, And those are words from the pattern instructions, the stipulations. This is a permanent publication that cannot be removed, even if this court could order it. And obviously it can't, because this is a First Amendment case and an injunction is not appropriate. But we could not have it taken down from the SEC's website, even if we had wanted to. But let me point out, there are 10 factors that the North Carolina pattern instructions cite that the jury should consider in a presumed damages award.
Counsel, before you go to 10 factors, can we just go back to Judge Gregory's question for a moment? And in answering it, I thought you were saying we know that people in foreign countries. So how do we know that? That's what I was trying to get at.
There is evidence in the record. There is, there's evidence in the record of from Google Analytics of how many people went to Puma's website and viewed it and where those IP addresses are. I don't have the site for that specific, but it is Google Analytics from Puma's website. We do not have that from the SEC, but it is a permanent form and cannot be removed. To the point, opposing counsel says that there was no real world harm here. And I want to just point out the standard of review, given the fact that Puma did not move under Rule 50, Mr. Martinez completely avoids the standard of review that applies here after failing to move under Rule 50. When there's the Bristol Steel case and the Minter case is very clear that where there's not a Rule 50 motion and there's an attempt to bring a Rule 59 motion for a new trial, the court's review is exceedingly limited and is only for a complete absence of evidence to support the verdict. Now here, to go to the 10 categories, and I won't go through all of them, but let me just say the 10 categories, this is the most damaging allegation, an allegation of clinical trial fraud against the founder and CEO of a $2 billion a year company whose primary mission is to ensure the integrity of clinical trials. And it wasn't just made against anyone. It was made against Dr. Eshelman, who is one of the most prominent and extraordinary leaders in the United States pharmaceutical industry. He's contributed so much to the pharmaceutical industry that the UNC Pharmacy School, the #1 pharmacy school in the United States, thought his contributions to the industry and to UNC were so significant that it named the pharmacy school, the #1 pharmacy school in the United States, after Dr. Eshelman.
And opposing counsel's point was that none of this seemed to have hurt his reputation. He went through a whole list of, Hall of Fame, this and that. What's your response to that argument?
Yes, Your Honor. So the 10 categories, Puma attempts to focus only on category 5, which is the category 5 is the proof of actual harm. The proof of actual harm. The Puma asked this court to ignore categories 1 through 4 and also categories 6 through 10 and focus exclusively on category 5.
So basically, you concede almost factor 6, but you say that the other 9 factors weigh heavily in your favor.
No, Your Honor, we do not concede. And as Judge Dever recognized in his denial of the Rule 59 motion and also in his summary judgment decision, that Dr. Eshelman did in fact allege, and there is evidence in the record and proof of actual harm here. And that is the loss of retirement years.
He testified. Is that right? We're relying on his testimony and his friend's testimony.
Yes,
but you're right.
Dr. Eshelman testified about the loss of reputation. I'm sorry, excuse me. The actual effect on the publication. There's unrebutted evidence that Dr. Eshelman testified to that he lost years of retirement. For a man who is
Counsel, is there any evidence besides his testimony and his friend's testimony as to the harm caused?
There is certainly evidence that the presentation was sent to Bank of America analysts.
Right, I understand that. But we're talking about in contradistinction to all of these awards and the Man of the Year and his extraordinary, the University of North Carolina naming the school after him. Is there anything that you have that you can point to and saying this was withdrawn because of this?
He certainly lost years of retirement.
That's what he testified to. That's why I'm saying, in addition to his testimony and his friend's testimony, is there anything else?
The friend's test, it was industry, and it was, excuse me, I apologize, Adage Capital. It was Phil Gross. It was the largest shareholder of Puma, who testified that if someone was involved in fraud, it would have lowered his estimation in the community. And in fact, Dr. Eshelman did lose the proxy contest here. We shouldn't lose sight of the fact that Dr. Eshelman did in fact lose the proxy contest here. And if I could come back to the retirement point, Dr. Eshelman testified that he felt he had to continue working because if he had retired, he's on the board of directors of publicly traded multinational companies. If he had retired in the wake of these allegations of him being involved in clinical trial fraud and filed with the SEC, if he had been, it would have confirmed the belief that this was true, that he did, in fact, he had to work longer so that the industry and that those of Dr. Eshelman's peers and those who didn't know him, that he wasn't slinking off and retiring after this damaging allegation was made. And as a man
Counsel,
in his 70s,
you can go on and argue whatever you want to, but I think you should reserve a substantial amount of time for them.
Thank you. Let me just finish on this point on damages. For a man who's in his 70s, who has the financial resources that Dr. Eshelman does, his time is his most valuable asset. His time lost with his family, with his children, and with his grandchildren when he was required to work for, at the point of the trial, it was 3 additional years. At that point, now it's been 5 to undo the harm that this caused. Let me turn to.
Would you turn to this? And this is the question I have about this per se. This was said that he was involved in a clinical trial where fraud was clinical trial fraud, right? So that it was in the context where he's saying that whether our company should have this person on the board whose company was involved in these clinical trial things, correct? I mean, isn't that the broader sense of it? You asked about interpretation. One interpretation is that PPD had a responsibility in that clinical trial. Within that clinical trial, there was fraud. So could have been a meaning that, in the larger sense, involved means he was involved because he was the head of that company at the time that they had responsibility for a clinical trial? Is that a fair interpretation of involved?
No, Your Honor, and I want to make one fact, I want to pause and make one fact perfectly clear. Dr. Eshelman and the company he founded, PPD, were the victims of this clinical trial fraud. PPD uncovered, blew the whistle on, and reported this clinical fraud, reported this fraud committed by a third-party doctor who was not a PPD employee, reported it to the drug sponsor Aventis, and also, which Mr. Martinez does not disclose to this board, reported it to the IRB. The IRB is an entity created by FDA regulation that is duty bound to reports to it, to the FDA. And the jury heard all of this evidence. And if you look, going back to the per se question, if you look at the context in which these statements were made, the presentation talks, the title itself talks about how Eshelman continues to demonstrate a lack of integrity, and his misrepresentations are no surprise given his history. And Mr. Martinez in his brief talks about, well, he gives this example about the Astros and talking about the general manager of the Astros who wasn't actually involved in the cheating scandal. But the more apt analogy is saying that the Atlanta Braves or the Washington Nationals, who were the victims of the cheating scandal, were involved in the cheating scandal itself. And what is remarkable here is that opposing counsel is trying to relitigate the issue of falsity through the guise of this per se ruling. And it's just not appropriate given the failure to move under Rule 50, which is completely ignored in the argument here in the standard of review.
I'll just ask one quick, then you can move on to damages. Mr. Martinez said that your client, that Mr. Eshelman took responsibility. Is that correct? Is that right?
So when he did not, so when the entire, I think Mr. Martinez is taking that clip entirely out of context. It's a clip that was shown
Give us exactly what was taken. What responsibility was taken, if it were? I'm just asking you, did he?
So when he was pressed at the hearing, he says, "I'm the CEO, the buck stops with me." It was a much more general statement than saying, yes, I knew there was fraud and I accept responsibility. I didn't report fraud. In fact, the congressional testimony was very clear that PPD did in fact report these misrepresentations to these issues to the IRB. So I think the clip is taken entirely out of context. The jury heard it, watched it, considered it, and rejected it in terms of saying that the statements at issue in this PowerPoint presentation, the jury concluded that they were false overwhelmingly, and based on the damages award, thought that they were false in a significant way. Let me turn briefly to attorney's fees, Your Honor. Attorney's fees are mandatory.
If you're not going to argue damages, you're making a mistake. Go ahead.
So I don't think that the award should be remitted at all, Your Honor. Particularly given the standard of review here, that there has to be a complete absence of evidence in order to remit or to grant a new trial. To go to the point.
No, not for the remittitor. That's not the case. Not a complete absence of any damages, a complete absence of the damages award that we've given. Right?
Correct. And a complete
okay, and so your position is no remittitor. I'm not going to argue about that we were entitled to the entire damages award. Is that your position? Because then it doesn't, we have nothing to say we have nothing on the other side of his remittitor argument. But if that's what you want to say, fine.
I don't think that a remittitor would be appropriate here. Judge Dever considered under Rule 59, considered the factors that the North Carolina pattern instructions say are appropriate for this kind of award. The only argument here is that there is no evidence of actual proof of harm. I respectfully submit that given the years of retirement that were lost, particularly we find the plaintiff as he comes, someone with substantial means, the value of those lost retirement years to someone of Dr. Eshelman's stature and means, this is not, I would argue it's significantly
I thought
more.
I heard opposing counsel say that several times prior to trial, when asked about damages, Mr. Eshelman's response was $7.5 million.
That was the initial estimate in the complaint. Of course, it was amended once discovery concluded, and I'm not concluded, but as discovery was ongoing, it was amended in the initial disclosures itself. And Dr. Eshelman testified, and there was a basis. Mr. Martinez talks about the Fort Knox case and how the number can't be arbitrary. The Fortnott case really just stands for the proposition that it can't be an arbitrary multiplier. There, the lawyer actually said to the jury, you should just pick an arbitrary multiplier, which is certainly not what happened here. In fact, the record evidence is that Mr. Auerbach, and what we argued to the jury is that Mr. Auerbach had received compensation in a 3-year period that was valued at $52 million. That is in the stipulation. And in this case, there had been a 3-year period where the defamation had stood. Mr. Auerbach had testified based on the strength of his own reputation. He was able to monetize his own reputation to the tune of $52 million. That was the basis, it was the symmetry and the basis for the argument as to why we asked for $52 million. Dr. Eshelman thought we should have asked for more based on his deposition testimony.
Counsel, but that's someone, and everyone has a right to give a number to the value of their life and enjoyment, $52 million. That's the question. That's the difference between putting a number on the value you put to your years of life and then what the damages are, because that value is the value. You mean to tell me he's going to live less years? What are you talking about?
This is the value that the jury put on, and there has been.
What basis would the jury have to put value on his life like that? I mean, everybody wants to live. I mean, a poor person, because you mentioned his stature, I'm sure that's important, but a poor person has a value in life too. So I mean, if somebody says, I put $52 million was it worth for my life in the time, that would be adequate too, right, for anybody, right?
Well, given that Dr. Eshelman was one of the most prominent leaders in the pharmaceutical industry,
I know
there
you
are
said
thousands
that,
of
but
people.
there's no evidence that there was any diminution in that value, in that reputation. As a matter of fact, he got awards, and was he taken from any boards he was on? No,
he was
right?
He was intending to step down from those boards and was not able to step down from those boards because it would have confirmed the
money for being on the boards.
He certainly lost the value of those years of retirement.
Did he receive money from being on the board?
I believe that there was some. Yes, I believe there was some nominal amount for being on the boards, but the pattern instructions are very clear. And the Supreme Court in the Gertz case has said that juries can award substantial sums even without proof of loss of reputation. That's the Gertz case. That's the United States Supreme Court. And so there has not been a single, the Fortnott case was not a defamation case. And the World, I apologize, the other case that counsel mentioned, World, I'm sorry, I'm misremembering the name, that was also not a presumed damages case. There has not been a remitter of any presumed damages case, and Mr. Martinez is asking this court for the first time to remit a presumed damages case, and the cases that we cite are comparable. Steve Wynn was awarded $17 million of damages based on an oral statement by the Girls Gone Wild founder, who was someone that was not really a credible person to be making those statements. Here, Alan Auerbach did have a solid reputation in the pharmaceutical industry and made these statements in a permanent online global forum. And the pattern instructions also recognize that this needs to compensate for possible future harm, not just current harm, not just, and certainly not, it does not require actual proof of harm, but also future harm. And when industry insiders are using SEC filings to due diligence, this will never go away. And Dr. Eshelman's grandchildren, when they will not know, his great-grandchildren will not know him. He will be gone. All they will know is what is available about him online. And the jury heard these arguments, and their award is entitled to great discretion, particularly with the standard of review that applies here without a Rule 50 motion.
All right, thank you so much. Mr. Martinez?
Your Honor, just a couple points focusing mainly on the damages. First of all, Your Honor, I think it's notable that my opposing counsel had nothing to say really about the number of people that viewed the defamation. I think what she pointed to is essentially the same numbers that we were pointing to. It's very hard to, of course, to estimate the SEC, people who viewed it on the SEC website. But as I said earlier, there's really no reason to believe that any substantial number of people did, because if they had, and if it had harmed Mr. Eshelman, we surely would have seen some evidence of harm presented.
What she did bring up, which I had not remembered, was, of course, it's permanently there.
It is permanently there, Your Honor, and I think by that logic, then any amount of damages would be sort of in play whenever you have something that's a defamation that's posted on the internet, because as we all know, it's very hard to delete something from the internet. I don't think that can be the law, especially in a case like this where—
Well, I don't think that analogy is quite right, because the SEC, it's a particular source that people in the industry look at. It's not just looking on the internet, period, and a particular knowledge that they would be interested.
But I don't think there's any reason to believe that anyone is going to be searching for this through the presentation materials that came up in the context of a proxy fight that has long been over, and that they're going to be sort of searching through that and look on slide 13 or 12 of a presentation that Puma put up many years ago.
Couldn't they just put in his name and get it?
I don't know the answer to that, Your Honor. I don't know if it's searchable, but I don't think we don't have any reason to believe that in the real world people are actually doing that. And certainly there's nothing in the record to that effect. I think another thing that my colleague pointed to was testimony from an individual at Untitled Chapter, Mr. Gross. If you look at that testimony, that's at JA page 772, he's very clear that he didn't believe what he saw. And so obviously that couldn't have caused harm to Mr. Eshelman. Opposing counsel talked about the self-serving statements about lost retirement, but as Judge Gregory pointed out, it's certainly the case that Mr. Eshelman was, or almost certainly the case, and I would be very surprised if opposing counsel would actually dispute that he received significant payments for his service on private sector boards, seven boards, a number of which were private sector boards, in addition to all the other evidence we have of his reputation sort of remaining. I think it's also notable that—
But, sir, he testified that was, and we have to take his testimony as credible, because you didn't have contrary testimony to what he said about this, and he said he wanted to retire. And he didn't want to do this. And, I don't have wealth like that, but I can certainly understand that. He had plenty of money to live on. He wanted to go cruise.
Your Honor, I think fair enough, he did say that. I think if you want to look at the record transcript and see what weight to give it, I think that's fine. I don't think it can get you anywhere close to the damages award that it was asserted here. Certainly, Mr. Eshelman knew of this purported desire to retire at the time that 4 times before trial, he was estimating his harm at only $7.5 million. And so there's really no new information he would have had after that would have justified an award of this size. Finally, on the damages, I was sort of surprised my opposing counsel thinks that the best comparable award is the Steve Wynn Award. I mean, that was a case in which Mr. Wynn received a very similar figure, $17 million, but where the defamation at issue was about threatening murder, and it was put on Good Morning America, which is a television program that has 4.1 million viewers. I mean, if that's the best case they have, then I think it's absolutely clear that this damages award is too big and has to be remitted. One quick statement with respect to the facts. Judge Gregory, Chief Judge Gregory, you were asking about this. I don't think it's the case. I don't think it's fair to say that, as my opposing counsel said, that Mr. Eshelman was simply saying he was sort of captain of the ship and the buck stop was with him. I would encourage you very strongly to look at that congressional testimony, especially at pages 1597 to 98. Ms. Locke says that PPD was the hero here. They reported the fraud. What actually happened was that there was a PPD employee who was a whistleblower, who was the one who really was the mover here. The congressional testimony shows that PPD called her, its lawyers called her multiple times, basically telling her she wasn't allowed to report this to the FDA. And
this is all about whether this is defamatory per se?
That's right, and just to contextualize
the fact. Well, you waived that argument. So.
No, Your Honor, with respect, I think we've preserved the idea of whether it was defamatory per se. We haven't made a truth argument in this court, but I do think that the actual facts inform the way that you should construe the statement. And I think that in this case, we had a good argument to make, given what was said in the congressional testimony, the fact that Mr. Eshelman's senior executive This is at page 1597 of the JA. The senior executive told congressional staff that Eshelman knew about the fraud and didn't report it. And then Eshelman himself accepted responsibility on page 1598. Now, you may disagree with us and the jury disagreed with us about the truth or falsity of the statements, fair enough. But when we're talking about what the statements intended to convey, I think that those facts illustrate that what we were intending to convey was not that he personally committed fraud, but that he was essentially, he failed to report the fraud that he knew about or should have known about as head of PPD. Unless the court has any other questions, I appreciate the chance to argue the case, and we do ask the court to reverse or to remit the damages to a reasonable number.
Thank you, Mr. Martinez, and thank you, Ms. Locke, for your arguments. We would love to come down and greet you as we normally do in the Fourth Circuit, but we can't. But no, nonetheless, that we're very much appreciative of your arguments and your being here today. And
If we did come down, I would tell you each that these were two great briefs, really.
yes, yeah. Well,
Thank you, Your Honors.
Yeah, well
Thank
done.
you.
Well, yeah, good. I like Judge Moss gave you the whisper in your ear comments you would have gotten. So yeah.
I can never stop myself.
We said a lot.
An old appellate lawyer.
Well done. Good lawyering in the briefs. Thank you so much. Be safe and stay well. With that, I'll ask the clerk to I guess, adjourn the court for the next appropriate hour time.
The Honorable Court stands adjourned until this afternoon. God save the United States and this Honorable Court.